Thank you, Mr. Deputy Speaker. In his closing peroration, the Lord Chancellor said that he wished he'd been able to stay on as Home Secretary in the early 1990s administration for longer than he did, so as to introduce a measure of this kind. I have to say to Conservative members opposite, they are very lucky that he did not stay on for longer than the year that he was there, and I'm glad to have the approbation in saying that of the member for Shipley. For the Lord Chancellor as Home Secretary was the last in line of a number of very complacent Home Secretaries who'd allowed crime simply to rise and rise and rise. And as Michael Howard pointed out, it had doubled under the Conservatives, and it reached its peak under the Right Honourable Gentleman. And nothing that he did then, and nothing that he is now proposing to do today, will do anything to make people safer and to cut crime. Indeed, I simply warn honourable members opposite, for whom I've got very great affection, that they will face, in coming months, if this bill goes through, day after day, week after week, stories in the newspapers where judges and magistrates complain publicly that defendant X or defendant Y should have been remanded in custody, awaiting trial, but the courts had no longer had any power. And I say to the Right Honourable Gentleman, who had some experience of the criminal trial process, the provisions in Clause 73 and Schedule 10 in respect of restrictions on bail are wholly irrational and take no account whatsoever of the way in which courts operate and defendants operate. The court is not going to know whether or not it is to send someone to prison until it's heard the full case and it's heard the mitigation. I mean, and how are they to, if Parliament lays down that there is a prospect of a sentence, how are they to translate that into a real prospect of a prison sentence? But what even in the case where there is no a low likelihood of a sentence upon conviction, where the defendant simply refuses to turn up in court? The Secretary of State was obviously completely unaware of the contents of paragraph 5 of Schedule 10. I'm glad he's looking at it now. It's absolutely, I will in a second, absolutely explicit, completely unaware of the contents of paragraph 5, clause 10. What that makes absolutely clear, I'll give way in a second, what that makes absolutely clear is that even if the defendant fails to appear in court and he's arrested, he can't be remanded in custody unless the court has come to a prior decision. There's a real prospect of him getting a period of imprisonment at the end of it. It is mad, and he must look at it again. Of course I give way.
Mr Deputy Speaker, I'm grateful to the Honourable Gentleman for giving way. I wonder if he's considered subsection B of that paragraph, which makes it perfectly clear that if someone's been convicted of an offence in the proceedings which would include a bail offence, that the provision barring the granting of bail doesn't apply. And so if somebody failed to surrender, they would be dealt with as they are now in their absence, and they could be remanded in custody when arrested by the police. The same qualifying subsection is present on page 168, which deals with bail in other circumstances.
I'm sorry, he's failed to read the not in the first line of the new subparagraph 5a. A justice of the peace may not remind a person in custody under subsection 5 if the person was released on bail in non-extradition proceedings. And the explanatory no, of course I won't. The explanatory memorandum makes exactly the same point. Let me also just go on to say, in respect of sentences for indefinite sentences for public protection, I entirely endorse what my honourable friend said from the front bench. The Secretary of State made one of his sweeping statements to say that these sentences have been discredited. No, they haven't. By whom? By him, because he's been forced to save money on IPPs, having had to surrender the 50% cut in the bail discount, as he knows very well. But IPPs have worked, and he failed comprehensively to answer his honourable friend, I'll give way in a second. He failed comprehensively to answer his honourable friend from Shipley yesterday, who brought out that the reoffending rate for IPPs has been spectacularly successful. Of 1,449 released, only 11 have reoffended. And of course it's the case that these people, the Secretary of State laughs. What we're dealing with here is the most serious offenders who, under the law, are expected to show that they will go straight in the future if they're to be released. And I say to the Secretary of State who's laughing about this, that the laugh will be on the other side of the Conservatives' face when and if his measures go forward and people are then released before they are safe to do so and they commit further offences. He'll be the person to blame.
He is, of course, referring, using his figures, of the 200 people who have been released. There are over 6,000 of them still in prison who have no idea when or if they're going to be released. Their reoffending rate is, I agree, very low, but it is not actually a justification of the system. It's regarded by the vast majority of the respondents to our consultation as something of a disgrace that this measure has been put onto the statute book and is working in this way.
Mr Deputy Speaker, I take that, as they say in court, as an admission. At long last, he now accepts that the reoffending rate from those released under IPPs is low. Well, perhaps he'll now reassess his ludicrous claim that this policy is not working. I'm afraid I've had my ration. Let me, Mr Deputy Speaker, in the time I've got, move on to deal with the proposals for civil litigation reform. I established the Jackson Review and fully endorsed its conclusions in January of 2010, and I welcome the fact that this government is implementing it, but only in part. And what I want to do is to pick up the points made by the Right Honourable Gentleman, the member for Alnwick, and the Honourable Gentleman, the member for Cardiff North, about referral fees and associated matters. As colleagues will know, on Monday I published the results of an investigation into what I only describe as a racket in the motor insurance industry, in which almost everyone in the chain, from recovery firms, claims companies, medical experts and insurers themselves, are paying between £200 to £1,000 in referral fees. Everybody in this chain is on the take, and the total is running into billions. Since Monday, I've been overwhelmed with emails, which I'm very happy to supply to the Lord Chancellor if he wishes, from members of the public and professionals, with even more horrifying detail about the dodgy practices and frauds and near frauds which are now endemic in this industry, including one from a lady who explained, quote, she'd had an argument with her bicycle. She was the only person present at the time. She went to hospital, and ever since she'd been pestered to make a claim. I'm sorry, I've run out of my... and one solicitor wrote to me, referral fees are no more than a form of legalised bribery. He's right, they are the parasites eating away at the integrity of the whole of the motor insurance industry and associated professions, including lawyers. Their effect is to drive up costs and therefore premiums, and actively to encourage individuals to try their luck making claims for fictitious or, I'm sorry, I've run out of time, or wholly exaggerated injuries. And I accept, and I've accepted this publicly, that this comes as a result of the 1999 Access to Justice Act. It was based on recommendations in 1996 from Lord Wolfe. It had expectations which have not been met, and I was clear when I established Jackson and endorsed him to set up an immediate consultation process that it needed root and branch reform, and I'm perfectly happy to accept that. But I do say to the Secretary of State, and I'm very glad to hear his words, that referral fees with respect to his honourable friend are not, as he said yesterday, a small part of the problem. They are a central part of the problem. They're not a magic bullet. Other actions will also need to be taken. But unless he deals with referral fees, amongst other things, as well as changing the whole system, he will not deal with this extraordinary abuse that is taking place. Now, there are other changes I've asked the Secretary of State to consider. One is that there should be legislation, it could go into this proposals, to prohibit the payment of damages for so-called whiplash injuries, save where there's evidence, other objective evidence of serious injury, as other jurisdictions have already done. The regulators, the information commissioners and Ofcom should crack down hard on the patent abuse of individuals' personal data. I've taken it up, but I hope, as the Secretary of State responsible for that, he would too. There should be an urgent review of the effectiveness, or rather lack of it, of the regulation of claims management of companies, established under the 2006 Act, but that too is not working as effectively as it should. And one other thing, in my area, in Blackburn and many other urban areas in the country, honest drivers with impeccable driving records are now facing huge increases in premium, not because of any risk they remotely have any control over, but because of the level of claims by other people. It's a form of collective punishment, and it needs to be outlawed. Over the last 20 years, as a result of taxpayer investment in safer roads, driver investment in safer cars and more secure cars, there's been a dramatic fall in the number of accidents and the number of thefts from vehicles. There should not be any great steep increase in the insurance premium, but instead a fall. And it's time for there to be major reforms so that at long last the motorists can benefit from this investment.